Good morning, guys. My name is SHIVEN. I am a second year law student from WIPS IP Delhi and an intern at LEXIS and Company. So today I'll be talking about the topic malicious prosecution and false imprisonment. So malicious prosecution. It is a self-help remedy. Abatement by the plaintiff is available under limited circumstances. This privilege must be exercised within a reasonable time after learning of the nuisance and usually requires notice of the defendant and the defendant's failure to act. Reasonable force may be used to employ the abatement, and a plaintiff may be liable for unreasonable or unnecessary damages. For example, dead tree limbs extending dangerously over a neighbor's house may be removed by a neighbor in danger after notifying the offending landowner of the nuisance. In cases where an immediate danger, notifying the offending neighbor of the in cases where immediate danger to health, property, or life exists, no notification is necessary. An action for damages brought by one against whom a civil suit or criminal proceedings has been unsuccessfully commenced without probable cause and for a purpose other than that of bringing the alleged offender to justice. An action for malicious prosecution is the remedy for baseless and malicious litigation. It is not limited to criminal prosecutions but may be brought in response to any baseless and malicious litigation or prosecution, whether criminal or civil. The criminal defendant or civil respondent in baseless and malicious case may later file this claim in civil court against the parties who took an active role in initiating or encouraging the original case. The defendant in the initial case becomes the plaintiff in the malicious prosecution suit, and the plaintiff or the prosecutor in the original case becomes the defendant. In most states, the claim must be filed within a year after the end of the original case. A claim of malicious prosecution is a tort action. A tort action is filed in civil court to recover money damages for certain harm suffered. The plaintiff in a malicious prosecution suit seeks to win money from the respondent as recompense for the various costs associated with having to defend against the baseless and vexatious cases. The public policy that supports the action for malicious prosecution is the discouragement of vexatious litigation. The policy must complete against one that favors the freedom of law, enforcement officers, judicial officers, private citizens to participate and assist in the administration of justice. False imprisonment is a restraint of a person in bounded area without justification or consent. False imprisonment in a common law felony and a tort. It applies to private as well as governmental detention. When it comes to public police, the proving of false imprisonment is sufficient to obtain a writ of habeas corpus. The scenarios are taking hostage of a bank customer and employing by bank robbers, detention of a customer by business owner for failure to pay the bill, certain situations arising from state legislation like California Assembly Bill 1421. A robber in a home invasion ties hostage up and then takes them to a separate room. What false imprisonment is not. Under US law, the police have the right to detain someone if they have probable cause to believe someone has committed a crime. And in India too, there is the same scenario. There is one thing that is the shopkeepers have a privilege in false imprisonment. Many jurisdictions of India have a common law shopkeeper's privilege, under which he is allowed to detain a suspected shoplifter on store property for a reasonable period of time with the cause to believe that the person detained in fact committed or attempted to commit theft of property. So this is the privilege given to a shopkeeper or any other owner of the store who thinks the customer has committed a crime of theft. The privilege has been justified by the very practical need for some degree of protection for shopkeepers in their dealings with suspected shoplifters. So the requirements are in order for a customer to be detained, the shopkeeper must conduct an investigation on the store premises. The shopkeeper has reasonable cause to believe the person detained was shoplifting. Reasonable force, that is, should not be excessive. Fourth, the detention lasts a reasonable amount of time to gather all the facts. The privilege for most part is to be able to return the stolen goods. The shopkeeper may not force a confession. They do not have a right to conduct a search of the person and the objects within that person's control. Claim of false imprisonment. To prevail under a false imprisonment claim, a plaintiff must prove a willful detention without consent, without authority of law. The test of liability is not based on the patron's guilt or innocence, but instead on the reasonableness of the store's action under the circumstances. The trial of the fact usually determines whether a reasonable belief is established. A guilty shoplifter can still sue for false imprisonment than if the detention was unreasonable. Thank you.